Hello, howdy. So, family courts in Canada, specifically Ontario. The system is broken, very broken. And I'm not coming at this as a mother or a father point of view for this. I'm coming at it from the child's perspective. Not specifically me, but being an advocate for a child. And my experience as a mother being the voice for her child, but not wanting my rights necessarily being heard, or, it's not about that. So, my relationship with my child's father ended about 2 weeks before I found out that I was pregnant. So, then he found out that I was pregnant and immediately started stalking me and harassing me for months. Like, not 4, but 4 months on end. I had text proof of it and call log proof of it and voicemails. Eventually, I got tired of it and called the police. And the officer that came out told me that, in quotes, because I will never forget this, he said, "Give the guy a break. He just lost his girlfriend." After I showed him text proof and call log proof that he had been stalking and harassing me for months while I was pregnant. So nothing was done about it. Fast forward till my child was born. We had a son. I get out of the hospital after having him, and I notify him because I delivered 3 weeks early, so he wasn't expecting him to be born, but I took a few days in the hospital. I was kept there for 2 days, and I took a day, I believe, after being home to recoup and just rest up a bit after having a baby. So the day after that, I got everything together. I went to the courthouse and filed all the paperwork for custody, and process started. So, got underway, and for the first 3 months of our son's life, my exes, who was obviously the father, refused to see our son for the first 3 months of our son's life. Straight up refused. And I had proof of it. This was documented. And this while court is obviously in process. And it takes a long time, so, So, eventually, there comes a point when I am basically told, you need to let him have unsupervised visits, because I had legitimate worries about him either running off with him, because I had text, like in-text message threats from his family that they were going to run away with him. And that is why I didn't want him to have him unsupervised. Because at that point, there was no formal order saying who has custody. So if he did do that, he would have every right to, I would have no rights to say I want my child back because there was no custody. So that was my concern, as well as the proof I had of his lack of care for him, for our son, as well as the physical. He was physically abusive in our relationship. Now, I know that does not pertain to the child. You can be physically abusive to your partner or ex-partner and not to your child. But that was my concern, because there was no custody. There was no way I had any pull, any say, once he was in his care at that point. But eventually I was told that I needed to let him have that visitation. Still without having a custody order, so still there was nothing I could do if he did anything. But the court made me, so I did. He started having access. He'd show up for 1, maybe 2. He wouldn't show up for 2 or 3 on end. He'd go a month or 2. He's even gone 3 months. Again, without having any contact. He's canceled time and time again. He's just straight up not shown up over and over again. And I have evidence of all of this. But still, he is entitled to his access in the court's eye. That's what they said. So, I have all this evidence. It's submitted to the courts. They have it in front of them, the judge. We had 2 or 3 different judges throughout the whole process. So they had all of it, and they ignored it. They were like, and again, quotes, the one said, "That was him in the past. Let him show you what he'll do in the future." That's what one of the judges told me. After he looked at the evidence I had, the stack of evidence that I had, showing that he wasn't interested in really being an active father. He refused to see him for the first 3 months of his life. He was threatening to take him away from me, and there was no custody given at that point. He didn't care about his overall health or safety, as recommended by the pediatrician he's had since birth. He has ignored every single recommendation and order from that pediatrician, but has offered no professional medical counter to that, and has refused to show up or go to any appointments himself with the pediatrician and our son. So that's what I went through for that. I asked the one judge as well if at some point my son does not want to go with his father for a visit, if I have to make him. So I just wanted to know. But I was told yes I did, because he has rights, the father has rights. So I said, so if my child does not want to go, I have to force him to go against his will because the father has rights. And the judge said yes. And one of the judges, I don't remember which one it was, but one of them was not even a family law judge because our local system had a severe lack of family law judges. And there just was none available to hear our case at the moment, at that time. So the judge that was hearing our case didn't know anything about family law in general. So in one of the court appearances that we had along the way, I had accused the father of smoking weed while caring for our son. Now, obviously, that's legal now, and it was at the time too, which I wasn't claiming that it was illegal. I was just claiming that it's unsafe and not in the best interest of the child. As is the same as if you were drinking. You're not gonna get drunk while caring for a child. It's not legal, but it's not safe or in the best interest of the child. So, I make this claim, right? And the judge approaches him about it. And he claims then that he has never smoked a day in his life. Mind you, he comes into the courtroom that day reeking of weed. So much so, the judge himself sprayed the room with air freshener. But he accepted his response of, I've never smoked a day in my life. That is how screwed up the system is. So anyone that thinks that, at least in Canada, that the mothers get favored, there might be the outlier case where it was handled poorly and that's what happened. But as a general rule, that is not the case at all. In fact, the system itself likes to keep the family together. And a judge told me that, specifically, they want to keep the family together. If that can't happen, they still like to keep the child with the family together, meaning as much 50-50 as possible. And I'm not sure why. Like, I get that part. I get it. But I'm not sure why, when there's evidence proving one parent is unfit and doesn't care about the child, why they are still given that respect, I guess? Where does the child come into play? Where are their rights? Where are their feelings coming into play? Who's advocating for them? If they're getting told, you have to do this, whether you want to or not, because your parent has a right to see you, like, I don't know. It's deflating. It's frustrating. It's heartbreaking. It's just wrong. But that's the law. And child support, for anyone who is wondering, it is not a they don't take money away from people who can't afford to pay. That's not how it works. There are specific brackets that you fall into depending on how much you make. And the Family Responsibility Office, FRO, is only allowed to take 50% of the payer's wage if it comes down to taking the wage off the check. So it doesn't matter if, for instance, the payer was obligated to pay $1,000 a month. Just say, if he only makes, or she only makes, $300 in that whole month, FRO is only allowed to take $150 from that to give to the payee for the entire month, when the obligation was $1,000. So that means they're going to be behind that many months, depending on how much they continue to make, on top of needing to get regular payments as time goes on. So you can imagine how backlogged that can get. Which is also why parents should have full-time jobs if they can, and if they can't, there's reasons, and you can bring a motion to the court to assess that. And if you have proof of it, I'm sure it'll work out. So, also, depending on how it's worded, because this happened to me, the payer may not have to pay anything at all. Because in my situation, the payer, being the father, he quit his job during this whole thing, and he would not find another job. So at the time when the final agreement was made, in it stated that he didn't have a job, so he was not obligated to pay anything for child support. And if he got a job, he was to notify me of that. But there was nothing in there stating that he would then have to pay whatever amount once he got a job. Nothing. So because of how it was worded, he had an obligation to tell me if he got a job and where it was, but he did not have to start paying. I had to take him back to court to get that money, to even attempt to readdress it, because now he is working. And I'm sure when I do, he can just quit again. So there's that little tidbit. Yeah, just where are the child's rights and feelings, safety, health, all that taken into account? Because I just don't know. I had all this evidence. I still have it. Of proof that the father just isn't interested in really being a father, and he doesn't care about our son's health or safety. And he still gets visitation. He still gets his rights exercised. Doesn't have to pay child support. all that fun stuff. He has blocked me from moving even out of the city. I cannot move out of the city because of the wording of the agreement. And by the way, I didn't want to sign the agreement. I was just told by the judge that if I didn't, that if I proceeded to go with an actual trial, that it would be much worse for my child, that I would be left with even less opportunity for my child to be spoken for, you know? I don't know if that's true or if I got played, but that's what I was told, and I was just trying to protect my child. So that was the lesser of the two evils that I was aware of. And I probably got smoked. Probably. But you know what you know at the point, right? So that's that. And with that information, goodbye.